by DWM Management at National Bank Financial featuring MLT Aikins LLP. My name is Sienna Foynacy and I'm an associate with Dollar Wealth Management. At Dollar Wealth Management, we strive to inspire, create, and develop positive change by optimizing your wealth with investment and portfolio management strategies that are tax efficient and built with you in mind. Our agenda today will respect your time as we aim to keep this presentation short and to the point to maximize its value. I would like to introduce the head of Dollar Wealth Management, Romel Dalla. Romel is portfolio manager with 15 years of experience who combines his investment expertise with the team's in-depth financial and estate planning. Romel will now introduce the principles of MLT Aikins, who will then discuss opportunities, market outlook, and answer a few questions. I'd like to hand it over to Romel to tell you more about MLT Aikins.
Thanks, Sienna, and once again, thanks for listening in on our virtual seminar. I'd like to thank Harmon and Celia from MLT Aikins for joining us today. Estate planning is a very important part of your overall wealth planning and life strategy. So I'm excited that we have an opportunity to talk to a pair of experts in the field so you can learn about why this is so important for you and how you can take advantage of their advice to adapt your own estate plan with your life goals and objectives in mind. I'd like to introduce both of our guests formally. Harmon Mavi is a wills and trust estate lawyer with MLT Aikins LLP and leads the firm's estate planning and administration group in Winnipeg. Harmon was called to the Manitoba Bar in 2013 and received the Trust and Estate Practitioner designation from STEP Canada in 2016. Beginning in March 2021, Harmon will also be providing services to the firm's clients in Calgary, Alberta. Celia Vallel is a partner at MLT Aikins LLP, specializing in the areas of taxation, corporate and commercial law, and charities and not-for-profits. She is also a graduate of the CPA Canada In-Depth Tax Program. I'd like to ask Harmon and Celia to begin their presentation.
Hi, I'm Harmon Mavi. I'm here with my colleague Celia Vallel. Today we're going to talk about some select issues in estate planning and administration. I'm going to briefly discuss some key questions in estate planning, touch upon probate planning, and discuss will contracts. Celia will talk about the family trust and how that might fit into the estate plan, as well as some key issues that arise if you have corporate assets and are dealing with an estate administration. So in terms of estate planning, this is a prospective plan. So you're planning for what might happen when you pass away and how to leave as significant legacy for those you leave behind in as efficient a manner as might be possible. Some of the key questions in terms of determining an estate plan are: what's the type of asset at stake? Whether it's a pension plan, an RSP, an insurance policy, a corporate share, or real property. Different assets have different tax attributes, have different constraints on them in terms of what you can do from a succession viewpoint. The second question to ask is, how is a particular asset owned? Is it owned by a person? Is it owned corporately, or is it owned by a family trust? If it's something you don't own individually, you cannot actually gift it by will. If you own something jointly, then it passes outside of the estate by right of survivorship. Who is the asset being gifted to? Is that person a spouse, a child, a charity, or other? The tax consequences can be quite different, depending on who the beneficiary is. Often a gift to a spouse may result in a tax rollover, but a gift to a child does not. Can the asset be gifted? Are there any contractual legal constraint on the intended gift? Are you prohibited from making a gift by virtue of the Family Property Act? Could there be a dependence relief claim? Are you gifting farmland and there's constraints in Manitoba in being able to make a gift of farmland to a person who is not a Canadian citizen or permanent resident? Or are there any prenups, go-haves, or separation agreements in play? who the intended beneficiaries of the asset are, where do they live, and can they handle the money. If an intended beneficiary lives abroad, that can trigger some estate tax or inheritance tax issues that one needs to be cognizant of. Today, we're only going to mention some very specific things from the estate planning and administration viewpoint. Obviously, we're happy to assist any clients barring conflict in setting up an estate plan or through an estate administration process. Probate fees, this is relatively new. These have been much maligned and were eliminated in Manitoba effective November 6, 2020. Other provinces in Western and Eastern Canada, however, do continue to impose probate fees, and usually this is a fraction of the estate value. The most significant probate fees end up being in BC, Ontario, and Nova Scotia, where they are 1.4, 1.5, or 1.695% of the estate value, respectively above a certain threshold. What is probate planning? Probate planning is primarily a way to avoid probate fee exposure. So this was done in a variety of ways in Manitoba and elsewhere. In Manitoba, this becomes less meaningful given the elimination of probate fees, except in discrete circumstances. But there are a few common ways to accomplish probate fee planning. One is multiple wills, and I'll touch upon them later. The most common is beneficiary designations and declarations. Joint ownership and alter ego and joint partner trusts are also options. But in this presentation, I'm only going to talk about multiple wills and beneficiary designations in some detail in the coming slides. Probate planning is one of those things in estate planning that I would always say handle with care. There are lots of ways to get this wrong. And I'm going to touch upon some of those as well. The beneficiary designations, declarations, these are exceedingly common. These can happen with respect to a variety of assets. Most common are insurance policies, RSPs, REFs, TFSAs, or pension plans. These can be useful in reducing probate fee exposure in jurisdictions where it is applicable. These can ensure that a beneficiary receives funds quicker. Through a beneficiary designation, monies are distributed outside the estate, so they don't entail personal liability for an executor if a distribution occurs before the executor receives a clearance certificate. How can these go wrong? Beneficiary designations can get stale. So if you have a beneficiary designation for an existing RSP and you get married or enter into a common law relationship, the previous designation doesn't change. So if that's a parent or a previous spouse or a common law partner, then unless you actually change the designation, the earlier designation still remains in place. Separation or divorce doesn't revoke a beneficiary designation, and the former spouse may continue to be the beneficiary. So it's quite vital to ensure that a beneficiary designation is changed to what you intend in case of separation or divorce, barring anything that you might be obliged to do under a separation agreement. A beneficiary designation can remove liquidity from the estate, which may be required for paying its liabilities or taxes. This most commonly arises if, let's say, a person has a significant amount of money in an RSP or a REF. Let's say the RSP or the REF is $500,000. The rest of the estate assets are $100,000. If the RSP goes outside of the estate to a person who's not a spouse or a common law partner, there's no rollover from the tax viewpoint and taxes payable, but the CRA is going to chase the executor of the estate first to pay the taxes, notwithstanding the fact that there isn't enough money in the estate. And it's also possible that a minor or disabled person may be named as a beneficiary, and there isn't an appropriate trust structure. So let's say if you've designated a child as a beneficiary and they are under 18 at the relevant time, no trustee is named, and even if a trustee is named, there isn't an appropriate terms of trust that are set out to go along with that designation. But on the assumption that a minor is designated as beneficiary, no trustee is named, the money is going to get stuck until the minor gets to age 18, and somebody would have to apply for a legal guardianship of that money to be able to access that for the minor's benefit. And finally, a beneficiary designation can go wrong if, let's say, one of the named beneficiaries predeceases. Example, if you have 3 kids, you've named them as beneficiaries of an insurance policies. One of the kids passes away, then unless there's something quite specific in the designation that guides the money elsewhere, the money is just going to go to the surviving children. So if, let's say, if the deceased child had his own descendants, those descendants would receive a share from the designation. An insurance trust declaration is a specific kind of a beneficiary designation. Its proceeds for this trust come from the proceeds of a life insurance policy. The trust declaration specifies the trustee who receives the funds, the beneficiaries, and the terms of the trust. This functions a lot like a will, but just for the money that's coming from that insurance policy. This can also be included in the will, but it's often preferable to do this as a standalone document. One, for the sake of privacy. 2, it just makes it easier to get the money from the insurer when the time comes. And these can work quite well for if you have a large policy that you hold personally. So a policy exceeding $1 million or $2 million that you own personally, it might make sense to do an insurance trust declaration that determines exactly what happens with that money. And there are also certain advantages of doing it this way from the creditor protection viewpoint, assuming that the trustee and the beneficiaries fall into a particular class of persons. The other tool for probate planning that I'm going to touch upon is multiple wills. Multiple wills work this way. So you carve off your estate into 2 if you have significant wealth held through a corporation. The primary will covers all assets except for the corporate assets, and the secondary will covers all assets that are not corporate assets. And in this sort of planning, you would only submit the primary will for probate and pay probate fees where they're applicable only on the assets included within the primary will. This is a fairly common planning strategy in both BC and Ontario. The legislation in BC requires different executives into the primary will or the secondary will for the strategy to work, but it's been considered in case law and it works fine in both of those jurisdictions. It also worked in Manitoba over the last few years. However, it may not be as meaningful as a strategy any longer in Manitoba unless you're really concerned about privacy. Anything that's an estate asset and is covered in the grant of probate that's been sought, the value of it needs to be declared in a filing that gets filed with the court and becomes public information. So if you're quite sensitive in terms of maintaining the privacy or the valuation of a corporate interest, and you don't want that to become public, then it might still make sense to do a multiple will structure. And it's also meaningful if you have corporate assets and you anticipate moving to BC or Ontario. We just have a brief example of multiple wills and what sort of probate fee exposure they might limit if that structure is followed in either BC or Ontario. So assuming you have Mr. Shareholder who has $10 million of assets, and half of these are comprised of corporate assets with both shares and shareholder loans held through the corporation, and the other assets are non-corporate assets. So if you had one will that you're probating in Ontario, then you would be paying almost $150,000 in probate fees. If you're doing a multiple will structure and carving off corporate assets from the probate filing, then probate fees would only be about half of that. And you're saving about $75,000 in probate fees on the corporate assets. In BC, this is a similar result, but you'd be saving about $70,000 in probate fees in that fact pattern. The key issues that are relevant in terms of doing the structure is these wills have to be very carefully drafted. The assets governed by each will must be clearly set out. One will cannot revoke the other, so they need to speak to each other. Also need to ensure that it's efficient to pay any debts and taxes if you're using a multiple will structure. So particularly if you have different executives, as you're required to do in BC, you need to make sure there's sufficient ability for the executives to actually pay the relevant taxes that are going to be assessed with respect to the entire estate, whether it's going to be covered into one will or the other. And you also need to make sure that if you're leaving a specific amount in one will, and there isn't enough assets in that part of the assets covered by that will to make that payment, then that any deficiency can be supplied from the secondary will. And now I'm going to pass this on to Celia, who's going to cover the certain aspects relating to family trusts.
So when putting together your estate plan, it's really important to consider both whether it might be necessary to introduce a new family trust, or and also in conjunction with that, considering the impact of any existing family trusts to your estate plan. So there are some key benefits to introducing a family trust. One of those benefits is asset protection. So trusts hold assets for their beneficiaries, and these assets are protected against creditor claims in many instances. Another benefit is maintaining confidentiality. So wills, when they enter probate, they are public documents. In contrast, sorry, previous slide. In contrast, probate does not apply to property held in a trust because the trust assets are not legally owned by the deceased person. Another advantage of family trusts is that assets with an accrued capital gain can be distributed to the beneficiaries of the trust on a tax-deferred basis. There's also the issue of deemed dispositions. So when an individual dies, they are deemed to dispose of all their assets at fair market value for tax purposes. So the individual has a capital gain on the difference between the fair market value of the assets on death and the adjusted cost base of the capital assets. In contrast, assets held by the trust are not subject to the deemed disposition on death. And so if someone dies and their assets are in a trust, that could reduce the estate's final tax liability. However, something to keep in mind is that trusts are deemed to dispose of their capital property every 21 years. That's a very important point. So it's necessary to look at trusts as they're coming up on their 21-year anniversary to ensure that appropriate planning is conducted to avoid that deemed disposition. Another benefit of trust is a capital gains exemption applicable for qualified small business corporation shares. So a trust can be used to multiply the lifetime capital gains exemption amongst its beneficiaries. So those are some key benefits to family trust. Next slide, Harman. So it's also important to consider existing family trusts within the estate plan. important to take a look at the beneficiaries of the family trust and compare it with who you want to benefit when you die. For instance, take a look at the language of the family trust. So if there's a situation where there's a new spouse or children born outside of the marriage or non-resident children, it's important to consider whether these individuals are considered beneficiaries of the family trust, and if not, do you intend to benefit those individuals, and should some other means of benefiting those individuals take place under your will or through beneficiary designations. Next slide. So other aspects to look at are taking a look at the trust agreement and considering whether the trust agreement has a power to appoint trustees on someone, and is it permitted via a will or some other means. And so when someone's will is being drafted, it's necessary to consider whether to make those appointments within the will. And another thing is the power of appointment. Does the family trust mandate the property? For example, in the case of a common disaster or other similar contingency, will it be disposed with consistently with the provisions of someone's will? Another aspect that's sometimes used is a letter of wishes. A non-binding letter of wishes is sometimes used. It's drafted, it doesn't carry the weight of law, but it gives the trustees an idea of what to do with the assets in the trust upon the death of a specific person. So this can give guidance to the trustees on the death of an individual, what they should then do with the assets in the trust. Next slide. Another important consideration is there are proposed changes to the trust reporting rules contained in the Income Tax Act to be effective for taxation years and ending after December 30th, 2021. So there are new filing obligations that are introduced. So right now, there are certain family trusts that do not need to file a T3 trust return. However, the new provisions in the Tax Act expand the filing obligation so that they apply to most discretionary family trusts. In addition, there are additional disclosure requirements with respect to certain actors within the trust. So, for example, the name, address, social insurance number of the settlor trustees and each beneficiary of a trust, and any person who has the ability to exert influence over trustee decisions will need to be disclosed to the CRA. In terms of kind of the consequences of this, this could give the CRA greater power to monitor things like association between corporate entities. So there are complex rules in the Income Tax Act that determine whether various corporate entities are associated. And if they are, one of the consequences is that they have to share the small business deduction. So these new reporting rules could potentially give the CRA more of an opportunity to discover such relationships, and the consequence is that multiple entities would need to would be identified as having to share the small business deduction. So that's just something to keep in mind with respect to existing family trusts some changes that are coming up soon. And if you're considering introducing a family trust, this is information that you'll have to disclose to the CRA very shortly, provided that the trust reporting rules go through. So the next section I'll pass over to Harman.
So I'm gonna briefly talk about will contracts. So a will contract is a contract to leave property to another person by will. So it's either a promise to leave a specific property or an amount of money to another person on death, or having already made a will, agree that you won't change that will on that particular point. And even if a will is revoked, the contract or changed, the contract is may still be enforceable depending on its terms. Or however, these contracts can be subject to a claim of a creditor or a dependent. The case law on this point is this should be a written contract and should be either made into seal or specify the consideration that's making the gift binding. So in order to receive a promise, it can't just be an empty promise. So dad can just say, I promise to leave you this house when I die. That promise is just an empty promise unless I say, okay, dad, I'm going to pay for your mortgage, and in exchange, you will leave me this house when you pass away, or you will, or dad has signed that promise under a seal. When are they relevant? So they can be relevant in a few circumstances. One, and the most common, is a mutual will agreement. So often in a blended family where two spouses are making wills that look a lot like each other. So husband says, I'll leave everything to wife. Wife says, I'll leave everything to husband. But when we both pass away, then we want to make an agreement that says that whatever is left at the end of the day gets split equally between all of our children. So both the husband's children and the wife's children, if they're not from the same marriage. Other agreements can also contain obligations that need to be incorporated into the will, and these could be shareholder agreements. And this is not uncommon in family corporations. So let's say a child becomes involved in the family business and puts in a lot of effort. Mom and dad agree that, when we pass away, you can inherit the family business, and they put that into the shareholder agreement itself. These are also common in prenups, postnups, and cohabs. So these could be things along the lines of one spouse agrees to leave a particular house or a particular amount of cash or some other assets to the surviving spouse if he or she were to predecease. These are also often common in separation agreements, where a spouse is obliged to maintain a certain level of insurance or other assets for the benefit of either the previous spouse or for the benefit of their kids. Or this could just be a standalone will contract that's catered to particular circumstances. So I briefly discussed these earlier. Notably, with respect to separation agreements, I want to clarify that if a provision is being made for a particular child to be a beneficiary of an insurance policy or another property, and that child is under the age of majority, then ideally the agreement should also speak to who the agreed upon trustee of those funds would be if a child were to inherit or become entitled to inherit those funds before they get to either the age of 18 or an older age that the spouses agree upon. And then now I'm going to pass this on to Celia, who's going to briefly touch upon certain things that need to be paid attention to when somebody passes away and they hold an interest in a corporation at the time that they pass away.
So it's important to understand the tax consequences on the death of a shareholder. there is the potential for tax inefficiency in such a situation, and there are various techniques that can be used to mitigate this. So the key objectives in postmortem planning are to eliminate double tax at the personal or estate level and to minimize tax as much as possible at the corporate level. There are a number of factors that need to be considered when planning is being contemplated. This includes tax attributes of the shares owned by the deceased, the nature and tax attributes of the assets that are within the corporation itself, tax accounts of the corporation, including the capital dividend account, refundable dividend tax on hand account, and the general rate income pool, as well as the intentions of the beneficiaries and their effective tax rates. Next slide. So there is a potential for double tax. So at the personal or estate level, on the death of a deceased person, there's a deemed disposition of the shares held by the deceased, resulting in a capital gain. If the assets of the corporation are then distributed by dividend, or if the corporation is wound up, the estate will have tax on the dividend and a capital loss. So this can result in double tax. In addition, at the corporate level, if the assets of the corporation have inherent capital gains, or if there's a potential for recapture, and these are disposed of, this can, in some circumstances, create a third level of tax. One strategy that's used is capital loss planning. So there's an election available under subsection 164 sub 6 of the Income Tax Act. So an election can be made to carry the estate's capital loss back to the deceased terminal return to reduce the capital gain arising on death. So what this does effectively is replace capital gains arising on death with dividend treatment. It may be appropriate where the corporation has a capital dividend account balance or RDTOH balances. In order to qualify, it's important to note that the loss must be recognized in the first taxation year of the estate, and the estate must be a graduated rate estate. Next slide. Another strategy that's used is the pipeline transaction. So kind of basically how this works is, so because there's a deemed disposition of the shares held by the deceased on death, there's a capital gain, and as a result, the adjusted cost base of the shares is then high. So these shares with a high adjusted cost base can be sold to a new corporation in exchange for a promissory note. That corporation is then amalgamated with Holdco. The corporate assets contained in the amalgamated entity can be used to repay the notes. Capital gains treatment is preserved. And what this does is effectively convert the high adjusted cost base of the shares into paid up capital. And the dividend otherwise arising on the distribution of the corporate assets is eliminated. There is also bump planning that can be used in conjunction with this to increase the tax of corporate assets, the tax cost of the corporate assets. So these are all very complicated planning strategies. So in general, when an estate has private company shares, it's very important to seek accounting and tax advice on a timely basis so that one or more of these strategies can be used. I'll pass it over to Harman to wrap up.
So overall, in conclusion, it's important to look at the overall pictures of one's assets and liabilities and develop an estate plan with the appropriate tools. And the estate plan isn't just the will, it might also include beneficiary designation, assuming they're done with care. If there's a significant insurance policy that's personally held, an insurance trust declaration should be considered. Multiple wills might be appropriate for clients with significant corporate interests, and one would have, particularly if they are or have a deep connection with BC or Ontario. And finally, the family trust isn't covered by the will, except to the extent the two tied together under the relevant provisions of the family trust. So it's fairly important to make sure that if a meaningful amount of the family wealth is included in the family trust, it's appropriately considered within the overall plan. And finally, if somebody passes away with the corporate interest, it's vital to ensure that timely tax planning is done in the estate administration to avoid double or triple tax exposure. And now on to questions.
Wonderful presentation, you two. Great job. And I just have a couple questions here that I'd like you to address. So since the introduction of the tax on split income rules, is it worthwhile to have a family trust?
So the tax on split income rules did have a significant impact on how family trusts were used. So previously, a common planning strategy was to have the family trust hold private company shares, and then income from those private company shares in the form of dividends were split amongst adult beneficiaries. So their marginal tax rates were utilized to reduce the overall tax paid by the family unit. So in many cases, this type of planning is no longer possible using the family trust. So it is no longer advantageous. But there are still important benefits to having family trust. So I kind of touched on some of those before. I would say the ability to multiply the capital gains exemption in certain cases would be a kind of a key factor in determining whether a family trust could fit into an estate plan. And then there are the other factors such as asset protection, benefits, confidentiality, and ability to roll assets out to beneficiaries, avoiding a deemed disposition at death, but also keeping in mind the 21-year deemed disposition. So these are all other ways that a family trust can still be utilized. So it may still be worthwhile in situations to implement a family trust planning strategy.
Romel, you're on mute. Sorry.
I did it again. It's going to happen every time I do one of these things. Can you take off the presentation, please? So we can see your face. Thank you. And so the question is, what are the most common mistakes that individuals can make with respect to their estate planning?
So the two most common ones are actually not doing your estate planning. So a significant number of Canadians don't actually have a will.
Yeah.
Never made one. If you don't make a will, the province makes one for you. So it's often, your spouse will, if you are not in a blended family.
I did not know that. The province will actually make a will for you. That does not sound good at all.
It's called the Intestate Succession Act. So,
yeah. Wow.
The key problem that's going to arise is if you're a young couple and you have young children who are under 18. Yes, if you both pass away, they would be likely the beneficiaries, but the money is going to get stuck in a very cumbersome process before they can be appropriately provided for. And that's one of the key reasons I would point out. Always make sure you, in fact, have a will that does what you want it to do. Within the constraints that you have based on family property, etc. The other common error is letting beneficiary designations or your will get stale. So this is detailed work when we're doing estate planning. We want to look at what the beneficiary designations on file, what the relevant institutions are. If they need to be updated, they should be updated. I've seen an astounding number of clients who still have, yes, they've been married for 10 years, but I set up this RSP when I was 21 and I designated mom or dad as a beneficiary, and they're still the beneficiary. Or having a will that you did when your kids were quite young, but they're not much older, but one of them lives abroad or one of them lives in the States, and you might be leaving them a significant amount of assets, which might trigger the need to do some planning from the estate tax viewpoint in terms of structuring that gift. So you'd want to make sure that, what will you have, you look at it every 3 to 5 years, make sure it still makes sense to you overall. Same with any beneficiary designations, and if it doesn't, or you want advice, then talk to us or talk to another lawyer and get the appropriate advice.
Okay, a couple of extra questions I have. So in your experience, how strong and does an estate plan have to shield the estate and the beneficiaries from legal challenges? Like how often are these things taken to court?
So wills are commonly challenged in very particular circumstances.
Okay.
So if you have a blended family and you've made a will, I'm leaving everything to my kids, and not making a provision for the spouse, that's calling for a challenge. You might have a prenup that protects that plan a lot better, but you'd also always want to make sure that any obligations under the prenup are covered. And if they're not covered, it's very likely it's going to be challenged, assuming what the two spouses have in terms of assets when they pass away.
Okay.
The other
question. Sorry, keep going if you have more to say on that.
The other fairly common one is if one child is preferred over another. And in relationships within families can deteriorate, or they can be built on from time to time. It's quite essential from our perspective, and we're doing estate planning, is we keep very detailed records of what exactly happened, why exactly that plan is being made and the way it's being made. The client understands the consequences of making that plan. Yes, it's possible that a child who's been left out might challenge that will, but if the client wants that to be enforceable, then absent a dependence relief claim, often it will be, but you'd want to make sure as a lawyer that it's appropriately documented if the will were to be challenged.
Okay, thank you. So a couple other questions. Celia, what you mentioned a lot about family trusts. What size of assets does it make sense for someone to put into a family trust at minimum? What size does it make sense that, to have one, or maybe just, there aren't enough assets, does it make sense to create a family trust?
So it's not so much, I guess, the size of the assets. So when assets with an accrued gain are transferred into a family trust, there's a capital gain. So that's something to keep in mind. You wouldn't just take normally shares of your private company and transfer them into a family trust. However, For example, when you have a company and you anticipate that there will be lots of future growth, a strategy that you could use is to do a freeze, depending on the particular circumstances. So what you would do is you would freeze the value of that company in preference shares, and then you'd get the family trust to subscribe for new common shares. So if it's a company that could meet the, or shares that could in the future meet the definition of qualified small business corporation shares, when that company is subsequently sold, you could multiply the capital gains exemption amongst the various beneficiaries of the trust. The capital gains exemption is indexed with inflation. It's between $800,000 and $900,000 of capital gain that can be shielded for the 2021 tax year, I believe. I don't know the precise number, but if you're looking at that level of accrued gains, and provided that the company makes provided that the company qualifies, the shares qualify, there's various criteria that need to be met. That could be a very beneficial planning strategy.
All right, well, very good. Once again, I sincerely appreciate both of your time. I know that you're both busy professionals and work at a very exciting and big law firm that does a lot of work for a lot of people in a lot of places. So grateful for you both. Thank you so much for sharing your expertise. I gained a lot out of this. I learned a lot of things, and hope to share your knowledge with as many people as I can so they can benefit the same. So thank you both. Just to close, you know, we're happy to obviously talk to you, to our clients and friends who need estate planning advice, and certainly happy to refer you over to Harmon and Celia in the case that your estate planning needs take it into that direction. So thanks everyone for listening. Have a great day and goodbye.